Good afternoon, everyone. My name is Lluc Cerda. I'm a senior associate here at Samfiru, Tumarkin. I'm here to answer your questions today on the employment law Q&A. If you have any questions related to your employment, anything at all, feel free to put those questions in the chat. We're going to get to as many of them as we can today. I'm always happy to provide some information to everyone out there on their employment rights. I'm also the managing associate of our Calgary office. So we're located in 3 provinces across Canada. We have offices in Ontario and Alberta and BC, so that we can help as many Canadians as possible with their employment rights, including obtaining severance when you're terminated from your employment. A lot of people have questions about what kind of severance they might be entitled to. We get a lot of different information out there. Is it a week per year? Is it a month per year? Which one is it? It may be that it's neither, all right? So actually, the best way to find out what your severance entitlements are is to visit our website, pocketemploymentlawyer.ca. We have a very nifty severance pay calculator on our site. You answer 4 basic questions, and we'll let you know what kind of severance you're looking at if you're terminated. If you've been terminated, if you think you might be terminated or curious, feel free to jump on there, take a look at what you may be entitled to. All right, we have our first question come in today from Vincent Favreau. Vincent asks, I'm currently on LWOP because of a vaccine policy. I guess what that means is leave of absence, leave without pay. Okay, so what I'm understanding here. I had COVID 2 weeks ago, and now I cannot be vaccinated for 8+ weeks according to the government. Can I ask for an accommodation from my employer? That's a very interesting question. So a lot of things will go into that question, but I think you're absolutely right. If you cannot be vaccinated right now, then the employer would have to accommodate you. So essentially what you'll need for that is to get a doctor's note of some sort indicating that you intend to be vaccinated, but you cannot be vaccinated because of your current medical condition. And then basically the doctor will advise when that'll change, if that'll change, or if this is a permanent restriction that you cannot be vaccinated. And once you have that doctor's note, that triggers the employer's duty to accommodate you. They have to decide whether they can accommodate you at work without it rising to undue hardship. Absolutely. First step, whenever you're requesting an accommodation, such as a medical accommodation, the first step, though, has to be going to your doctor and getting a medical note. All right, that's always the first step. So if you have that, or if you're in the process of getting that, then you forward that to your employer. Absolutely. We have another question from Vic S. I have been on LTD for 10 years. I have just received a form in which the insurance company wants to know my CPP disability gross and net monthly amount. The CPP disability inflation increases affect monthly LTD benefits. That's a great question, Vic. Unfortunately, I don't do disability work at our firm. We do have a disability department, a disability practice area, and they would definitely be able to answer your question. My understanding is that we also have a disability law show that you can attend and speak with one of our lawyers that specialize in disability law and help you answer your questions. So the next show on that will appear shortly on your screen. Just watch out for that, and you'll know when you can jump onto our disability law show and ask that question. Soon asks, I love your videos. Thanks for doing this. I'm on a commission-based salary. How long is long-ability payments calculated? To you, Ellie, I just want to tell you I have an update for you, Vic. We have on Thursday, 25th, we have a disability law show with our partner, Ottawa, Alex Lucifero. So tune in on Thursday, August 25th. Alex will be happy to answer your question. So again, we have a question from Ellie regarding how I'm on a commission-based salary. How's long-term disability payments calculated? And again, this is a question that might be best asked to Alex. Ellie, I'm not trying to avoid the question, or L, sorry, but I don't want to give you an answer that's not correct. I can tell you how severance is calculated for commission-based employees, but I'm not sure if that's the same for disability LTD payments. You'd have to ask Alex. But in terms of severance, basically, when you're terminated from your job and you're a commission-based employee, you're claiming is the commission you would have earned had you not been terminated over the severance. So let's say you're one of those employees that's entitled to 2 years of severance. Well, basically, we're going to have to figure out earned in commission over that 2-year period, and that's what a judge would award you in terms of severance. So it might seem that it's very complicated, or more complicated than it would be in the case of an hourly employee or a salaried employee. It's actually not that complicated. We're generally going to look at your past year of commission base prior to your termination. Sometimes we'll look at your last 3 years to get an average. If for some reason the past year might not be appropriate, for instance, we just came out of a pandemic, your sales might have been lower than they have been historically. And if there's no reason to think that your commissions would continue to be so low, well, then we might use the 3-year average, for instance. So you're welcome, Vincent. You're welcome, Vix. Thanks for your questions. It's always great to be able to provide some information to people out there. I often get asked questions unrelated to my practice area. So people might ask me family law questions. They might ask me, criminal law questions or stuff like that. People don't necessarily realize how vast the law is and how specialized lawyers can be. So I've done a little bit of disability law, in university, and criminal law and family law and all of that. But basically, if you're looking for legal advice, best to go to someone that specializes in that area. That's always a good call. You have an uncle or a cousin, but not necessarily in the area of law that you're looking for. You might have a cousin that does corporate law, and then you get terminated from your job, and you go talk to that person about what your severance entitlements are, and they might get it completely wrong, and it's just because that's not their area of practice. If you have a question about employment law, it's important that you speak to an employment lawyer, and that's what we're trying to get you the right information straight from the source. So if you have any employment law questions, feel free to put them in on the chat. We're going to get to as many of them as we can today as possible. We're always happy to good information on what your legal rights are in the employment context. I have a question here from JX2. In the event that you're sent that requires proof of action but not informed of that requirement when scheduled, is your employer required to pay you a full day if you're turned away? All right, so that's a very interesting question. Generally, in Alberta at least, there's a 3-hour rule. All right, so the 3-hour rule basically states that if you're working for less than 3 hours, then the employer has to pay you at a minimum 3 hours, but of the minimum wage. Okay, so you might make a lot more than the minimum wage, and you might think, well, I'm entitled to at least 3 hours at my base wage. That's not what the law says, unfortunately. I wish it did. It's not that I'm, a big fan of the way this is worded, but it's 3 hours at the minimum wage, which is currently $15 an hour. So that's what you would be entitled to. And I think the fact that, you're going there ready to work and no one's told you you can't work would entitle you to that 3-hour rule. Absolutely. Yeah. And we have a question here from Robert on Facebook. My manager has threatened me several times saying if I quit, they will make my life difficult. Is it possible for them to prevent me from taking a new position? So absolutely not, Robert. You cannot be prevented from quitting a new job. All right. I mean, that always goes back to one of the fundamental principles of law in Canada is that we don't have indentured servitude, which is another word for slavery. All right. So you're entitled to leave your employer and go work somewhere else. That's a fundamental rule in Canadian law and all of the world. No one owns you. You can do what you want. That said, there might be a clause in your employment contract that says you can't compete with your employer for a certain period of time, or you can't solicit former colleagues or clients. So those are non-competition, non-solicitation rules. It doesn't mean you can't quit your job. And the only way they're valid is if they're in a written employment contract. All right. So you have to basically first determine if you have something like that in a written employment contract. And if you don't, to worry about. Unless you're a very senior employee, if you're like the CEO or a senior vice president, sometimes you can't just leave your employment and set up a competing shop. All right. But other than you're like one of those very senior employees at a company, they have to have a non-competition clause to create any kind of problem. And I can tell you about non-competition clauses. They're presumptively unenforceable. What that means is the judge is going to ask the defendant to prove to the judge why the judge should enforce this non-competition clause. Judges view non-competition clauses as a barrier on trade, as a barrier on and as something that prevents people from being gainfully employed. So they're not all that keen on enforcing non-competition clauses. That said, they're enforceable. I haven't seen your non-competition clause if you have one. So you should definitely get in touch with us at contract so that we can see if your non-competition clause is enforceable. If it isn't, then there is nothing at all preventing you from quitting your job and going to work somewhere else. Even if you have a non-competition clause, doesn't mean you can't quit your job. You can still quit your job. There might be a period of time where you can't work for a competitor, but you will still be able to work. So that's not a problem. All right. So definitely nothing prevents you from quitting a job. The only kind of caveat would be that you might not be able to compete with your employer or poach their former clients or staff for a period of time, not indefinitely. So for that, we need something employment contract. If you have one, we're happy to review it, give you some better advice on that. JX has a follow-up question. BC tends to be a 2-hour minimum, but my industry is usually booked on a 4-hour minimum. So JX was the one asking us about if he's turned away from a work site, whether he's entitled to any minimum pay for that day. So that's the other thing, of course, Jay. I mean, what we have in employment law, in things like the Employment Standards Act in BC or the Employment Standards Code here in Alberta, we have minimum entitlements. So it could be that there's an industry practice. It could be that there's a policy at your job that if you're turned away, work for a certain amount of time in a day, that you'll be provided, as you say, 4 hours of pay, a full half day, and your full wage. And of course, that's fine if the employer is willing to pay you more than the minimum, then they can have that. So you should just make that claim. I would say reach out to your HR department, reach out to your manager, tell them, listen, I don't have the vaccine. You booked me for this job where there was a vaccine requirement to get on the site. They turned me away. I wasted a day that I could have been on another site that would have been with work. I want the 4-hour minimum rule to be triggered, and I want to receive a half day for my day, even though I wasn't able to work. Absolutely. So reach out to your employer, management, HR, see what they say. All right. We have another question. This one from Wendy, an email question. Wendy is asking, my employer to move me to a new position and cut my pay by 25%. I refused and didn't sign, and now they want to fire me. What can I do about this? All right. Well, the short answer, Wendy, is that if your employer does this and they do fire you, then you're owed severance. All right. So to keep in mind, an employer might approach you and say, listen, Wendy, what we have together is not working. We can either fire you with or provide you with this other job. The decision is then yours on whether you want to take this other job. And if you don't take this other job, then you're owed severance. All right. Now, an employer, you can't force an employer to keep you at your old job indefinitely, which is to say, listen, I don't want to be terminated and I don't want to take this demoted position. I want to keep the job I've always had. You can't do that. An employer can terminate you basically for any reason, including that your position has become redundant or whatever it is. But then they have to provide you with severance. So the decision ultimately that you have to make right now is, are you willing to lose your job? If you are, you're more than likely owed severance. Otherwise, option B is to take the demotion. But if you accept the demotion, you can't in 1 year say, well, listen, this is not working for me. I want my severance now. All right. So you have to choose one or the other. It's an uncomfortable position to be in. No one, but you want to be proactive about this. I'm happy you reached out promptly to us. There's unfortunately a very unhelpful decision that came out from the Court of Appeal here in Alberta, which is saying to employees that whose pay has been cut, that they don't have all that much time to decide about it. All right. They have, maybe 10 to 15 days. The employer tells you today, listen, I'm cutting your pay. What are you going to do about it? You have 10 to 15 days to reach out to a lawyer, get your legal advice, decide if you're willing to walk away from the job, and then let the employer know that you're not accepting the pay cut. So it puts a lot of pressure on employees, especially considering that you want to get some proper legal advice before you make this decision. So don't sit on a lot to think about. You have your bills to pay. Counting on your job for all this time. But if the pay gets cut, it's important you reach out to a lawyer as soon as possible. So you can reach out to us here at Samfiru Tumarkin. We're happy to answer your questions anytime. We're at employmentlawyer.ca. You type in that website into Google, employmentlawyer.ca. We will be getting in touch with you, set up a time so that we can speak to you and give you your rights when it comes to employment law. We have a follow-up here from JX2. I'm a gig worker and have been offered work at the same site through different employers. Sometimes they say there is a requirement, sometimes not. I've never been asked for proof when showing up. Yeah, so it seems like it's a very weird kind of situation, especially so late in the pandemic, right? I mean, we've come to a point where most employers are lifting their vaccine requirements. Even Alberta Health, who runs the healthcare system, has said there's no more vaccine requirements for any of our staff, including new hires, because we looked at the science. This is Alberta Health. This is saying we've looked at the science and prevent infections during Omicron. So if people don't want to get vaccinated, they might get sicker than someone who is vaccinated, but it doesn't rates. All right, that hasn't been established by science. So I find it odd now that employers are still requiring proof of vaccination, or just now starting to require proof of vaccination, when frankly the science is just not there to show that being vaccinated prevents transmission. So I would reach out to your employment agency, JX2, and tell them, listen, I have entitlements here to a half day. If they're unwilling to pay, you can reach out to the Ministry of Labor in BC, make a Ministry of Labor complaint. Ministry of Labor will investigate and order the employer to pay you your unpaid wages. We have another question coming in from Facebook here from Jenna. Laid off due to a large company restructure. Same severance offer than everyone else did. Should I accept the offer before the deadline? So, Jenna, I find that very odd that everyone at the company would get the same severance offer. Everyone is different, all right? And if you look at our website, when we try to explain to you how much severance you're entitled to on pocketemploymentlawyer.ca, you'll see that we ask you more than one question, all right? There's 4 questions that determine how much severance you're entitled to. And those questions are going to be, what's your age? What's your position? What's your length of service? And what's your salary? All right. So if those are 4 questions are different for each employee, then their severance entitlements are going to be different. Okay. So that's the reality of it, is that, it's not a one size fits all. All right. If you've been working there longer than another employee, then likely you're entitled to more severance. If you're a more senior employee in the corporation, likely you're entitled to more severance. So what I think is important is that you get in touch with us, Jenna, and schedule a time to speak with us, and we can explain to you what we think your severance entitlements might be. and whether your employer's offer matches what your severance entitlements are. And if they don't, we can help you obtain a better severance. Now, what I can tell you is that deadline that they put into the letter is arbitrary. There's no legal requirement that you respond within the deadline. In fact, if you're scheduled a time to speak with a lawyer and it comes after the deadline, I would say simply reach out to your HR department, whoever sent you the letter. Tell them, listen, I'm having this reviewed by a lawyer. I need more time. I want an extension. And usually it's going to be granted so that you can get proper legal advice. This is an important legal document. It's an important financial consideration, important financial question. You should make those kinds of decisions with proper information. Having consulted with a competent employment lawyer here at Samfiru Tumarkin, so we can let you know what your rights are. So don't be too alarmed by that deadline. That deadline is oftentimes extended. And if it isn't extended, it doesn't mean that you lose your right to severance. Far from it. All right. You have usually from the date of your 2 years to bring a lawsuit because you can sue your employer to get your proper severance. And that's why you come to us. That's why you come to lawyers, because we can help you get your proper severance through pre-litigation negotiations, or if need be, we'll start a lawsuit. We'll get you what you're owed. So that 1 week or 2 week deadline that they give you is not based on anything. It's arbitrary. Just ask your employer to extend it so that you can get the proper legal advice so you can make that's right for you and your family. We have a question here from Art on Facebook. Can my employer refuse my parental leave request or move me to a different position if I take parental leave? I'd like to take some time to support my partner when she gets home from the hospital. So no, Art, the employer cannot refuse your parental leave request. It's a protected leave under the Employment Standards Code. It's also in BC and so that you can take some time off to be with your partner. So no, they can't refuse to grant you your parental leave. You may have noticed that you're taking your parental leave, but once you've given them the notice, then they have to find a way to accommodate that. Furthermore, they can't retaliate against you for having taken a parental leave. So once your parental leave, they have to return you to the job that you had previously. If they return you to another job as you took a parental leave, then you can force them to put you back into your old job. All right, and we can help you with that if need be. So we'll just write to the employer, let them know, listen, this is not in compliance with any law to return Art to the job he had before. The job is still there. There's no reason why you would move him other than because you're punishing him for having taken a leave, and that's a no-no. That engages human right considerations, employment standard considerations, constructive dismissal considerations, a lot of things to be concerned about if you're an employer. That's absolutely the wrong way of approaching if someone is asking you for to take a statutorily protected parental leave. Absolutely. We have a question. Jay, hello. I've had my consultation with your firm today, but do not feel the person I spoke to was understanding that I want and need to move forward with retainment here, and instead was advised today. I think you cut off here, Jay. So, Jay, I don't have all the details of exactly. You were advised to delay. Okay. So, okay, I see here. So basically you were advised maybe to wait a bit before proceeding. So I don't have all the details of what the discussion was today. We also calls from people that think they might have been constructed. If that's the situation, let me explain to you what happens. Constructive dismissal is when the employer makes a fundamental change to a condition of your employment that entitles you to quit and seek severance. All right. However, both sides have the opportunity to have a judge decide whether the change was so fundamental that it amounts to a constructive dismissal. And if it doesn't amount to a constructive dismissal, then you will lose your case. You won't get severance, and a judge might rule that you actually voluntarily quit your position, which is not ideal by any means. So we oftentimes get people that call us that they think there's been a fundamental change. It could be that there's a poor working relationship, discipline that they felt was inappropriate or something like that. We know based on other cases that have gone before the courts on these issues, that it might not rise to the level of constructive dismissal. And what we tell these people is that often in our experience, this might just be the start and it might get a little bit worse. So keep us on speed dial, because the next issue, the next thing that the employer tries to pull might reach that threshold where now we can say, yeah, getting you out of there, we're getting you your severance. This is unacceptable. You don't have to deal with this. But right now, the employer might be, kind of not pushing it 100% in a hope that they can get even with no severance. All right. So that's obviously not ideal for anyone. So basically, what we recommend in those cases, keep a log, right? If it is related to working environment, issues with a colleague, with a manager, whatever it is, I always recommend to my clients, keep a journal. If something comes up at work, keep a journal, save those emails, so that you can have a refresher, a memory refresher when we do decide to move forward. Because it might be several months from now, several weeks, several months, and you might not have the best memory of what happened on that day, right? So you want to be able to also show that there's a trend. If it's every day they come and they pester you or they micromanage you or something like that, and you have that log showing, well, listen, on this day, on August 15th, it was one thing. On the 16th, it just keeps on going. At some point, the picture is painted, and we can go ahead and claim that you've been constructively dismissed. One incident of workplace tension might not be enough, even though it can be very hurtful, and make it seem to you that this cannot go on. But you want to go, you want to advance a strong case. The stronger the case, the better your severance is, especially in relation to constructive dismissal. So definitely you want to build your case a little bit. And I think that's what you mean by delay. It's not that we're delaying for the purpose of delaying. We're trying to build a better case for you. So if that's the advice that you were given, I think, heed that advice. Build a better strategy, better case for yourself. And then we're happy to revisit this once we have a bit more information from you. All right, we have a question from Eric Bellefeuille. I've been on unpaid sick leave for 1 year and 10 months. At 2 years, I will be fired on long-term disability, but I'm ready to go back, but I need to be fully vaccinated or I'm going to be fired. What can I do? All right, so essentially once your doctor has cleared you to return to work, then you go see your employer and you tell them to work. I might have a restriction. I might have some sort that says I can't lift heavy box, can't stand for too long, whatever it is. And then the employer has a duty to accommodate you to undue hardship. That's subject to their policies. So now it seems that your employer has a vaccine policy. So I don't have details as to why you don't want to get the vaccine. I see here you explained that you work for the city of Sudbury later on here. So if you're not getting the vaccine because you have a religious or medical exemption, then that's also something that needs to be accommodated. If you're not claiming a religious or medical exemption, then you can treat that as a constructive dismissal. If you're ready to work, there's work for you to do, and they just don't want to let you back to work because you're not vaccinated, then you can treat that as a constructive dismissal. If on top of that, there's human rights considerations, that makes your case even stronger. I mean, we have a recent decision coming out of Ontario, precisely the city of Sudbury. That's why it was interesting that you mentioned that. It was a union case that ordered the city of Sudbury to take back, or it was the medical unit in Sudbury, in order to take back a nurse who did not get vaccinated because she had a valid religious exemption that the Sudbury Medical Authority had turned down. And through the union grievance, the union was able to get the arbitrator to agree with them that, listen, there's plenty of case law all the way up to the Supreme Court saying that you have to accommodate people with religious restrictions. And now this woman is being reinstated with back pay and reinstated into her job. But if you don't claim a religious exemption, maybe you know that's not part of your religion or whatever it is, it can still be a constructive dismissal if you are terminated or placed on a leave of absence for not getting the vaccine. So definitely what you want to do is reach out to us. We can set up a consultation with you. We can speak to you and figure out what your rights are. So we're running out of time. I'm sorry for those that I haven't been able to get to, and I'm really appreciative of all of you coming in today and sharing your questions with me. My name is Lluc Cerda. I'm an employment lawyer. I'm a senior associate at Samfiru Tumarkin Employment Law. I'm also the managing associate of our Calgary, Alberta office. We have another show as soon as tomorrow at 12 p.m. Pacific time with my colleague, Madalena Viskne. So she'll be happy to answer any questions that we haven't been able to get to today. So feel free to tune in. I think we have 5 shows this week. So every day we have a show for you to get your questions answered, know your rights. Thank you for joining us today, and I hope you have a great rest of the day. Thank you.